Hello again, everyone. This is Professor McKenzie. Today we're going to be looking at Chapter 13, which is entitled Form and Meaning. We're going to be looking at some specific issues associated with contracts when they're in written form versus oral or verbal form. That's going to be a predominant focus of this chapter. We're also going to be looking at some issues when it comes to signatures and when contracts have a combination of written, printed, or handwritten elements to them. There's an order in terms of importance that judges will kind of consider when evaluating what terms will prevail in a contract. And so that's what we're going to be looking at in this chapter. The learning objectives for this chapter, by the end, hopefully, we can discern what kinds of contracts must be evidenced by some kind of writing under what's called statute of frauds, which I'll explain that in a few minutes. We'll talk about the effect of contemporaneous or side agreements and how they impact written contracts, and how to interpret a contract if elements of it are being, basically disputed. So that's our focus in this chapter today. Statute of frauds is a body of commercial law within common law. And the idea with statute of frauds is that some agreements are of such importance that we want to make sure that they are memorialized in written form. When we talk about contracts, I've kind of touched on this a little bit in the past few chapters. You can have a written contract, which I think most of us understand what that means. You commit something to writing. It's still subject to judicial interpretation if there's a dispute, but at least it's something that's written. Then there are also verbal, or sometimes called oral, agreements. And so there is no underlying writing. It's just a recollection of the parties and or possible witnesses to the agreement. And so with statute of frauds, what we're looking at here is that, we're not discounting that in some cases verbal agreements are okay, and if there's a legal dispute, then we're going to basically just rely on testimony of the participants to the case and or witnesses to discern what was the actual agreement. But there's a body or a bundle of cases that have to be in writing, and if they're not in writing, they're not going to be enforceable generally in a court of law. So I give the example, it's not in this textbook, it was in a previous textbook that I used to use, where the actor Mark Wahlberg is talking one day with Steven Spielberg, and Steven Spielberg essentially offers him a movie role. So it's like, hey, I'm working on this project, and we're going to be filming in a couple of months, and I'd like this for you to star in it. And so maybe they discuss compensation, they discuss points, they discuss residuals, they discuss all these different things, but everything is just verbal. And there's nothing that's actually written down. That isn't necessarily a problem. As long as the contract can be performed in under a year, a contract for services, there's no issue there with statute of frauds. If the contract is going to be a multi-year project, then that's different. That would have to be in writing. Again, I illustrate through this example my point that there are a lot of verbal agreements that are enforceable, and they can be worth lots of money. Don't think that because it's a high value, or maybe it's millions of dollars, that it has to be in writing, because that's not necessarily the case. The standard we look at is it required under that body of law called the statute of frauds. It does require noting that for verbal versus written agreements, sometimes when you have a written agreement, it may not be evidenced entirely in one single document. And again, that doesn't necessarily undermine the fact that we have an otherwise enforceable agreement. Remember, those elements we talked about: offer, acceptance, mutual consideration for a legal purpose, and everyone having contractual capacity. You can, under what's usually loosely referenced as a merger doctrine, you can kind of put documents together that are separate from each other to evidence, like pieces of a puzzle, we have a contract. And so a great example of that is if you have, let's say you put an ad, in the newspaper or online that you're selling something. Maybe it's a piece of real property, like your house. And so, that's like one snippet of that equation for contracts. And then maybe someone submitted you a letter saying, I agree to purchase your home at this price. Okay, so that's the acceptance. Maybe there's another piece of paper that documents, that there's consideration flowing. Maybe there was a down payment, and obviously, if you're selling a home, that's legal, and everyone having capacity. But if a dispute arose, the seller couldn't just say, well, we don't have an entire contract. We have bits and pieces of things here or there. Through the merger doctrine, the buyer could just say, look, I'm going to submit as, Exhibit A, the ad that was in the newspaper or online. Exhibit B would be my acceptance. Exhibit C could be, maybe the check that was the down payment, that evidenced balance due at closing or something. So again, just realize that you don't have to have everything in what sometimes is called the four corners of the document in a single document. It can be bits and pieces that are put together to show that an agreement exists. So this is the bulk of when we talk about, in terms of the examples under the statute of frauds, these contracts must be in writing for them to be enforceable. So prenuptial agreements. So if two people have decided to get married and, they merge their lives together, that's fantastic. But if you want to have a prenup, then that has to be in writing. There's no such thing as a verbal prenup. Agreement that cannot be performed within a year after the contract is executed, that has to be in writing. So, let's say you're leasing an apartment, and let's say the lease is for, 6 months. That does not have to be in writing, although it usually will be, but it could be verbal. You could go month to month, and that could just be a verbal arrangement. That's fine. But if you're going to lease, let's say this apartment, or it could be an office space, and let's say the duration is for 2 years, that has to be in writing. You cannot do that on a handshake. That cannot be a verbal thing. It has to be in writing if it's going to be more than a year. If you're selling goods that are valued at $500 or more, you need to have that as evidence in written form. An example here, and I know a lot of times people don't think of it like this, but let's say you go to Best Buy and you buy an iPad, and let's say it costs you $800. The receipt that Best Buy gives you actually is the contract, even though you don't think of it like that. It has the store's name that sold you the merchandise. It has itemized what you purchased at what price. It had your method of payment. Did you pay cash? Did you pay credit, debit card, or so on? Usually on that receipt, at the bottom or on the back, there will be terms and conditions in terms of exchange or return policy. So all of that in that one little strip of paper, even though we don't think of it as a contract, that evidences the transaction. So again, the law is very amenable to different ways in which you want to document in writing that this transaction occurred. Again, remember the effect of noncompliance. A majority of states hold that the contract's not going to be enforceable if you do not follow these rules pertaining to the statute of frauds in these cases. So, again, like I mentioned, if you have a prenup with someone you're going to marry, and let's say it's verbal, well, I mean, everyone could honor that agreement, if a divorce happens in the future, and that's fine. If everybody honors what they agreed to, there's no issue. But if a dispute arises, and let's say, during the divorce, one spouse is trying to, take a lot of the property, or, whatever is being asserted, and you say, well, that's not what we agreed to verbally before the marriage, that doesn't matter. Prenups have to be in writing. And even if they're in writing, they're hard to enforce sometimes. So you have to be very, very skillful in the drafting of it and how you present it to the other party, which that's a whole nother issue. Some exceptions to the statute of frauds, because obviously, we live in a world of exceptions. If there's an admission, so maybe, if both parties acknowledge that, yes, okay, this is what we agreed to verbally, then, even though you were supposed to have a writing, there are many courts and judges that will kind of say, okay, fine, if that's what you acknowledge and admit to, then we'll proceed based on that agreement. If there was, partial performance, or maybe we're trying to argue some sort of detrimental reliance, then those are some other examples too, where we can say, well, that this is going to be considered an exception to the statute of frauds writing requirement. Signatures under the law are very, very flexible. So whatever you intend to be your signature is your signature. Prince, I'm still amazed, that he passed away. I think it's been 5 or 6 years now. And so if you recall, there was a time where, he kind of left his name was no longer Prince, and it was whatever that image is that I have in purple there at the bottom of the screen. And that's what he referred to himself as, so if he signed a contract, that's what he would sign. And so, that's what he intended. If any of you ever watched like old Western movies, sometimes you'll see like a prospector, when they stake their claim with the surveyor, for their name, they would do like an X because they were illiterate, this particular character. And this happened in real life too. And again, if that's your intended signature, that's your intended signature. Again, however complex or not, you intend your signature to be, the law recognizes that is what it is. We've obviously, I've given you numerous examples so far in this course where the law has adapted to new technologies. And so when you think of like e-sign or e-signatures as part of like the Uniform Electronic Transactions Act, that's fine. We have completely digital contracts now. And so you never actually have to have anything physical in the real world that is on paper, your contract. It can be completely digital. And that's what you would submit as a digital file in court should there be a dispute at that point. The parole evidence rule, the idea with this, and this is another common law concept that we kind of brought over from England when we were colonized, like with the statute of frauds. The idea with the parole evidence rule is that we don't want to introduce at trial any type of verbal testimony if we have an otherwise complete contract. Part of this, and I think maybe this is the main reason, the justification for this is judicial efficiency. If we have a valid contract that's been signed and executed and it's in writing, why do we have to talk about what we negotiated, leading up to this agreement? The judge will just review the contract and then make a ruling. Is it enforceable? Yes or no? And if it is, what's the result? If we start opening up, well, this is what we negotiated or this is what we talked about, before we signed this final agreement, a lot of times judges are like, well, if something was that important, in the negotiation phase, and if it did not end up in the contract, was it really that important? Why are we delving into this? There are some legitimate concerns, which I'll show you on the next slide. Even if we do have a written agreement, there may be an instance where we're going to have to bring in some kind of verbal testimony at that point. So if the contract is maybe incomplete or maybe contains ambiguous, clauses or terminology, we may have to, say, okay, well, let's open up for some testimony to kind of discuss what did we mean when we included this as part of the agreement. If maybe as a party to the contract, you're alleging that there was some sort of fraud or duress, mistake, or illegality that induced you into signing the agreement. If you think the contract has maybe been modified, we live in a world of Photoshop, where we can manipulate digital information. So if you think that actually has happened, that could be a reason to open up, verbal testimony in a case. If you think that, there's some sort of condition precedent that was at issue, illegality, or just in general, if you think there's some aspect of it that's not binding, then those would all be reasons to say, look, maybe we need to kind of, liberalize the parole evidence rule and allow, at least on some limited level, some testimony verbal, so that we can maybe seek some clarification so that we can determine what is enforceable and what is not enforceable in this contract. Some tools of judicial interpretation. So depending on what actually is contained in the contract, some terms are given more weight than others. So as an example, and I'll show you in the next slide, how this kind of plays out. But writing normally takes control or precedent over typing. Typing takes control over like pre-printed forms. If an amount is given in words and figures and they differ, then the words control. And if there are any ambiguities in an agreement, normally those ambiguities are construed against the party that drafted the agreement. So, the burden kind of flows with them. This is a great example of how, we're talking about, well, which one, how do we enforce this in terms of these two checks? So you see there's two checks here. One where it says, well, both are made out to Bob's Grocery Store. And you can see that the amount in the upper left-hand check is for $53.34. And on the line where you have to write it out in words, it matches. It says 53 and 34 over 100. So they match. So if you're Bob's Grocery Store and you present that check, that is what the bank will process. They will, ultimately, as you go through, the banking system, which we get into more detail in business law too. But as that check gets presented to John Doe's bank, out of John Doe's account will be transferred $53.34 to Bob's Grocery Store. That's the check that's in the upper left-hand corner. The lower check, as you see here, there's an issue. There's a discrepancy. And so we see on the numerical what's written out, it says $35.43. So, whether it was intentional or unintentional, the 5 and the 3 were transposed in the second check. So, okay, so that's what you see as the numbers. On the line where you write out the amount, you can see that John wrote out correctly to Bob's Grocery Store the $53.34. Now, in terms of, if you present this, to an actual human at the bank, the human would most likely catch that discrepancy, and then they would be able to kind of, take that into account when processing the check. If you're taking a picture of the check, with your phone, and that's how you do your deposits when you receive checks, I don't know if the scanner software would pick up those differences. But here, regardless, the lower check on the lower right-hand side, even though the number part is written out, says 35.43, what actually this check will pay out is 53.34, because that is what is written out. It takes more effort to write out that 53.34 than it is to just write the numbers. So again, that's how, like judicial interpretation, that's how we actually apply some of these rules, So I've seen contracts where they're like boilerplate contracts, and then you have to either handwrite or maybe type in whatever is applicable, like the sale price. And so obviously, if it's a pre-printed form, okay, it's part of the contract. But for the sections where you handwrite in information, or if you type it in, and so it's a different font, or obviously handwriting, it's handwriting, judges will pay note of that. And when you type it in and it's a different font, or if you're doing handwriting, that's going to take precedent over what is just that boilerplate language that maybe just is, part of the pre-printed, verbiage that's in an agreement. So anyway, this was a fairly quick chapter on form and meaning. So please, as always, let me know if you have questions. Otherwise, I do hope you have a wonderful rest of your day, and I will be chatting with you all in the next chapter soon. Bye-bye.